Hello folks, welcome to Edipedia World, and I am Abhinay Gupta. So today we'll start with a very interesting concept. We'll learn about the compromises, arrangements and amalgamation of companies. Right? And this particular topic has not been included from the 2013 Companies Act. So for examinations up till at least May 2016, you will be asked the questions referring to Companies Act 1956 for this particular chapter, right? So we would learn about compromises, arrangements and amalgamation of company from chapter 5 of the part 6 of the Companies Act 1956, which consists of your sections from 390 to 396A. If you refer for the same to Companies Act 2013, you will have chapter 15 of the Companies Act 2013, which consists of section 230 to 240. But till March previous year 2015, this section was not notified. It was not applicable for your November 15 examination, nor is it applicable for your May 2016 examination. So students who are appearing for May 2016 examinations will have to write your answers based on Companies Act 1956. So with this, we advance ahead with the topic. So to start with, we'll try and understand the meanings, the basic meanings of compromise, arrangements and amalgamation. So what does compromise actually mean? In layman's term, it is an agreement between two or more persons for the ascertainment of the rights in the question of controversy. The Act has not defined what compromise is, right? But if you understand from the word compromise, from its literal interpretation, you will know that you are compromising for something, and this happens only when there is a dispute. So there will be compromise only in case of a dispute. If there isn't any dispute, you don't need to compromise for anything. So actually, compromise is the settlement of any dispute in the company. And on the other hand, if you talk about arrangements, then arrangements or rearrangements of the rights and liabilities of the members and creditors in a company is termed as arrangement. Again, there is no specific definition for the same in the Act, but that is what it actually means. So in case of arrangements, there need not be any dispute. It is the discretion of the company. The company may at any point of time decide that we need to rearrange the rights and liabilities of the members. It can be for internal reconstruction, reorganization of the company, or amalgamation of two or more companies. In these cases, the assets and liabilities of the members, the shares, the rights in the company will be diluted or maybe concentrated, right? So maybe the value of the shares will be decreased, the value of their share may be increased. So these are internal arrangements, and that will be for reorganizing a company. So there need not be any dispute in case of arrangement, but there has to be a dispute in case of compromise. So this is one of the basic difference that you understand by the word compromise and arrangement. And if you understand both the terms together, you will notice that in both the cases, the parties make concession and give up something, right? It is not about the total surrender. It is not the liquidation. It is not the bankruptcy of the company that you lose everything. No, it is about a compromisation. It is about a scheme according to which you agree to undertake something at the occurrence of a dispute, right? When there is a controversy, you seek for a settlement, and that settlement will be a compromise. Someone gains something, the other person loses something, right? But there is no case of total disruption. This was confirmed via a case referring NFU Development Trust Limited in 1972, according to which the decision rolled as forward that where it was proposed that members should abandon all their rights without the compensating advantage. And since it talked about abandoning all their rights, hence it was not termed as compromise or arrangement. Right? So this can be an important aspect that you may be judged upon in your examinations too. So moving ahead, we'll understand what amalgamation is. So amalgamation is one basic and very important chapter in your accountancy too. So over there you see that amalgamation is basically of two types, purchase and merger. AS 14 deals with amalgamation, right? So what does amalgamation mean? In amalgamation, there are two or more companies that are joined to form a third entity. or one is absorbed into or blend with another. For example, if you say there's company A and company B, they both can amalgamate to form company C. They both can amalgamate to form company A, right? When they both come together to form company A, it is absorption. And when they both come together to form company C, it is amalgamation. And you may also have consolidation of two companies where A plus B equals to AB, right? So if we get into a deeper understanding the term of reconstruction. So what is reconstruction? When you're talking about amalgamation can be of reconstruction type. In reconstruction, what we say is that substantially the same business is carried on, and substantially the people at the ownership of the company are the same, the creditors are the same. Everything remains substantially the same with a little alteration. Now, what are the purpose? Like, why do a company go ahead with reconstruction? That can be done so for reorganizing the capital structure of the company, for compounding with the creditors to settle the creditors for something low. There is a compromise for the creditors, okay? Or to extend the object of the company, the object clause of the company. They can also alter the rights which are attached to the class of company with the shares of the company or the debentures of the company. If certain shareholders have been given certain rights and they need to dilute the rights, they can subdivide the shares, right? The number of shares. So reconstruction can also be taken forward to compel the members to bring in more capital to the company. Right? By diluting their shares, they would require more inflow of the capital to the company. So how does reconstruction take place? Reconstruction can be taken place by selling off the entire company, by selling off some of its undertaking, some of its division under the scheme of reconstruction, by acquiring the majority of the shares of the other company, that is the takeover of the company, by compulsory amalgamation, reconstruction by the members voluntary wound up, creditors voluntary wound up. These are the modes of reconstruction of the company, right? And we have already seen what amalgamation means. Now, what is the purpose of amalgamation? Why do two or more companies amalgamate? They can amalgamate for tax benefits, they can amalgamate to affect the economies, they can amalgamate to eliminate competition from the market, right? To become a monopoly in the market. They can also amalgamate to completely utilize the capacity of a company, to mobilize the resources to acquire the assets of other company. There can be n number of reasons why two or more company amalgamate, right? They can amalgamate to maximize the economy of scale, to diversify, right? To capture new market, to eliminate competition. There can be n number of reasons why a company amalgamate. So I hope with this lecture it was very clear to you what compromise, arrangement and amalgamation basically they mean, right? Where there need to be a dispute, where there don't need to be a dispute, what is the proportion, is it a total surrender or a partial surrender? I think these terms and these concepts are clear with you. So that was the objective of the lecture. So moving ahead, we'll have to move with the procedures undertaken for amalgamation or reconstructions or the compromise or arrangement. How is it done? What are the steps to be followed? So we'll take up that portion into the following lectures. Until then, this is Abhinay Gupta signing off. Thank you.